Okay, I was just, we're gonna be live on YouTube in just a second.
Woo!
Yeah, really.
Yeah. In theory, well, I guess what's happening now is I've created a YouTube channel for this branch. The link to that is on the CCAP website. And that way we can hold hearings in a fashion. Our calendar gets published the same as always. And that way we can hold hearings that are open to the public with the building, with the courtroom locked. So that's the theory here.
All right.
Okay, and there's a 30-second delay, but we're up and running. And it's just, it gets further complicated because in order for me to be logged into CCAP so that I can pull up the case files and things like that, when I'm doing that, the laptop camera doesn't work, or actually the camera doesn't work. The microphone now does apparently work, which is why we got that feedback to begin with, because I have an iPad here, so that provides an audio and video feed for the YouTube channel, but it's more techie stuff than I would ever want to deal with. So we have Mr. Goodrich, we have Mr. Tanz. Has anyone other than Justice Point spoken to Mr. Davis this morning?
Just very briefly, I did.
All right. What does he want to do? Does he want to call into this?
At this point, my understanding is that he is fine with this hearing going forward and waiving his appearance for the purpose of this hearing. That's my understanding.
And and I put this in my email to the Ms. Longo. I won't do a final pretrial without a defendant, because one of the purposes of my final pretrial is to make sure that the defendant is aware of what the offer is, and whether or not he accepts it or rejects it. So there are other things we could deal with today. One, there's a joinder motion that is pending. So that I think is appropriate to deal with today. I don't know if either of you, well, I assume that you've all seen Mr. Davis filed some paperwork with the court that basically seeking to dismiss his cases. Hopefully one or both of the lawyers who represent him have seen this and discussed with him that that's not something that can happen at this point. Marissa, do we have a trial date at this point?
Let me just double check. Oh, also, we haven't called the case yet, so none of this is on the record.
Okay, let's call the cases then.
Okay.
Do we have Hannah on?
Hannah, are you on the phone?
Hannah's here.
Okay. Good morning.
We don't have a jury trial date. I don't know if, it was supposed to be for May 4th, but I obviously removed that.
Okay.
And we were going to use this day to maybe pre-select a new jury trial date, if that's even worth doing at this point because of what's going on. But
All right. Let's call the case and let's have this discussion on the record. Call the case.
State of Wisconsin versus James Anthony Davis, case 19 CF 3766 and 20 CF 325. Appearances, please.
State by ADA Elizabeth Longo.
Good morning, Your Honor. It's Avery Goodrich for Mr. James Davis on case number 19 CF 3766.
Good morning, Your Honor. This is Attorney Martin Tanz on behalf of James Davis on 20 CF 325, waive his appearance for the purpose of this electronic hearing.
Good morning. Thank you, everyone. The record should reflect that before we went on the record, there were a number of communications that were going back and forth. Somehow Mr. Davis got some confusing information, and he felt he had to show up today. This hearing is being conducted electronically. None of the participants in this hearing are physically in the courthouse. The court set up a Zoom meeting and sent invitations to the lawyers and court staff to join in that fashion. There are currently 2 criminal courts that are operating in the criminal justice facility, and I am told that Mr. Davis went to one of those courts today and was told that he didn't need to be in person, and I think he reconnected with Justice Point, and we did receive a telephone number for Mr. Davis. The cases were set for final pretrial and joinder motion today. It's the court's position that a final pretrial can't be conducted, or whether they could or couldn't, the court wouldn't conduct a final pretrial without the defendant participating, because the court would need to address the defendant personally as to whether the defendant was aware of plea offers and was rejecting them. However, there was a joinder motion. The court's view is that under 971.04, that does not qualify as an evidentiary motion, and so that can be done in the without the defendant's appearance. And we'll add to that that Mr. Tanz has waived Mr. Davis's appearance on the 20 case. So we've also had a discussion. Currently, the case was set for trial in early May. That is not going to take place. Jury trials there are no jury trials that are going to take place in Milwaukee County at this point through at least the week of June 8th. As a practical matter, it's going to take a long time to get these 2 cases tried, because when and if we're able to go back up, my guess is that every criminal court will have multiple in custody speedy trials that have been set over and set over. But be that as it may, we can pick another trial date today. Likely we should be looking at, frankly, August or September for those trial dates. The one issue that I did want to address, there is a joinder motion that has been filed. I'll start with you, Mr. Tanz. Have you discussed this with Mr. Davis?
I have.
All right. Mr. Goodrich, have you?
Yes, Your Honor.
All right. What is, Mr. Tanz, what's his position as far as you're aware?
I am not opposing the joinder motion. That's my position. I spoke with Mr. Davis about it yesterday, and that's where we're at.
Mr. Goodrich?
Your Honor, on numerous occasions in the past, I explained to him the law with regard to these cases arising out of the same operative facts. He and basically I'm saying I'm not in opposition as well. He did not give me an answer one way or the other that he truly understood. I think he was really hoping that the cases would be dismissed based upon the motions that he filed.
Okay.
So that was the extent of our conversation.
I also just want to add something to that. Mr. Davis, in his recent filings, he included some sort of like small claims action. And I just want to let the parties know that I scanned everything into CCAP into his criminal cases. However, I did not, on his behalf, like submit his information or his filings to the small claims department or any other department or person within that division. I just wanted to clarify that.
All right, thank you. The courts reviewed the joinder motion, and these cases do arise out of a very similar fact pattern involving the same primary witnesses. And it's very likely that even if they weren't joined, that an other acts evidence motion would allow the admission of much of the testimony of one in the trial of the other. And so therefore, I am going to grant the state's joinder motion, and we are going to join these matters for trial. This is it's not a somewhat unusual situation. It's a very unusual situation because Mr. Davis has two lawyers. Is the thought that that will continue as we move forward?
Your Honor, I have expressed a desire to Attorney Tanz that in the administration and efficiency of justice, because these cases are arising out of the same operative factual scenario involving some of the same parties, I would not have a problem withdrawing from the case. And I think that might be, I really don't know how that would be resolved. I know in the history of court cases, two attorneys can deal with different fact scenarios, but it only seems logical to me that there'd be one attorney handling both matters in this instance.
Mr. Tanz?
And I can, if I may, I can also
go ahead.
express, I can say for the record, it has not always been a cooperative relationship with myself and my client. He has indicated to me on numerous times that he would prefer to represent himself pro se. The opportunity was given to me to handle his other case, and the case that Mr. Tanz now has, and I declined that because I could foresee the possibility that I would have to withdraw. So I am not in opposition to removing myself from the case if these cases are joined.
Thank you. Mr. Tanz?
Well, I'm not opposed to taking these cases on behalf of Mr. Davis. The only problem here is with him not being here. That's not something that I discussed with him. He never expressed to me any dissatisfaction with Mr. Goodrich or any desire for me to handle both of his cases. But if that's the way it goes, I have no problem with it. I think the issue, though, is then we need to schedule a court date for a motion to withdraw from Mr. Goodrich on his case. And I'm also not appointed yet, so I'm sure I would be, but
So the SPD, all right, okay. Here's my suggestion as to how to resolve that. If the two of you are able to do a joint call with Mr. Davis, if Mr. Davis is in agreement, I would suggest that we execute a stipulation for substitution of counsel, and that we could do that without a court hearing. I would want a court hearing if he did not have a lawyer. And this was a situation where we were going to have to be going back to SPD to reappoint or to appoint a new lawyer. I'd want to address Mr. Davis personally. But in this scenario, I think that we could do this with a written document, assuming that he agrees. If he disagrees, then, then we'd need a court hearing.
okay. I will, we can do that. So so the understanding is that the future court dates will be on the record. At this point, I am not yet the counsel of record, but I may be going forward. Is that my understanding?
Yeah. So what would happen is if he is fine with this, you'll file a stipulation. And at that point, I'll sign an order allowing Attorney Goodrich to withdraw. We'll forward that to SPD so that you can be formally appointed on the other case.
Okay. All right.
Mr. Goodrich, does that work for you?
Yes, sir, Your Honor.
All right, then let's talk about the next court date that we want to set. We could set a trial date. We could set a status date. I'm a little torn. I'm sorry, go ahead.
I was gonna say, we're, for Miss Longo and for our court's calendar, we're setting trials already in mid-September. And then I have the court down for a huge chunk in September. So yeah, Mr. Davis, the earliest trial date I could give him is September 14th. Or if we want to even look out into October.
Okay. Well, that's pretty far out, but that's September 14th is, let's take a look here.
Or like the judge suggested, we could set like a status date in August if you want.
That'd be fine too.
It's just because I was on a call last week, Wednesday, and we're starting to look at the problems that we have to overcome in order to bring juries back into the building. You know, even when everything opens up, we talked about jury assembly and will we have to actually bring jurors into the sheriff's gym so we can maintain some social distancing? How will we bring up panels? How will they be comfortable in the court? And the scary number that John Barrett threw out is in a normal year, they send out 75,000 summonses to get 20,000 people to show up. And if that's in a normal year, I can't imagine, you know, they're going to have to send out 150,000 summonses to get 10,000 people to come in. So it's going to be a struggle. So we can set a trial date, but everything is just so fluid at this point.
Okay. Well, I guess my suggestion is, sounds like there may be some difficulties as far as getting this going, but we could, I think putting a date on the calendar at least gives us something to shoot for, whether or not that actually happens.
That's fine. We can set we'll give you, if that September 14th date works, we can give you a trial date for that.
Okay.
I'll note that I do have 3 trials already on that date, and one of them is a speedy, just FYI.
Well,
Okay.
Would you like to pick a date in October? I mean, I also just realized instead of a status date, we'll have to set a final pretrial date for Mr. Davis to know the offer. The court is available October 5th for trial.
That would work.
October 5th for trial.
Yes.
Yes.
I've got a trial date in Sheboygan on that date, so I'm not available. I'm sorry. You said October 5th, correct?
Yes. Yeah.
My bad. I am available on that date.
Okay.
Okay. So we have jury trial October 5th at 9 o'clock. And then do you want to set a final pretrial in August sometime? Like
Yes,
late
please.
August?
Yes.
Okay. The court is available the week of August 24th or the week of August 31st, preferably Tuesday or Thursday, those weeks.
The week of the 24th should work.
Okay, do you want to do Tuesday the 25th, Thursday the 27th, or Friday the 28th?
I would say the 27th or the 28th.
Attorney Goodrich,
28th works best for me. 28th,
okay. Morning or afternoon?
it doesn't matter, whichever works best for the court.
Let's do final pretrial August 28th at 8:30. Jury trial October 5th at 9 o'clock.
Okay.
All right. Anything else we need to talk about today?
The only thing, I guess, it's a housekeeping matter. So this stip in order, Mr. Davis does need to sign that, right?
Yes.
Okay. All right. That might be a bit of an issue because I know there's some thing about his being out of state, but I'll see what I can do.
Well, but you can mail it to him.
That's true. Certainly can.
All right.
Okay.
Okay.
All right.
Thank you very
Great.
much.
Thank
Thank
you.
you, everyone.
Okay.
Have a
Bye-bye.
good day.
Bye-bye.
How do I end it?
You can't, I can.